audio system. Right now, I fixed up this one, and I
Vikram,
was
thank you very
really,
much.
really, very thankful to you to invite me here to share some experiences from your side as well as from my side, and for the audience over the globe, actually, what is going on, what is thinking on mediation, because the various reasons have various meaning on mediation, actually, concept. Although we should be in one platform on the concept of mediation. It is it's from my on uh, uh, comments, right? Like this, because all of us, mediation, right? What is mediation? But the concept of mediation is differs from the reason. Suppose, for example, what is meant by mediation in Europe or America may not have the same meaning in Asia or Africa, right? Obviously, in Bangladesh or India, like that. Because in mediation here, especially in less developed countries, mediation is a new term, actually. So very few people have idea about mediation. Either they have learned themselves by having work experience. Few of them have some ideas by gathering training, etc. So there's a mixed conception. If I can give an example, you also we are just from same region. 25 years ago, mediation did not mean what is meant today. Suppose in India or in Bangladesh, we have village shalishi, right? Shalishi. It's type of, for the English speaker, it's a settlement by the villagers, village heads. So in one time, that was also termed as mediation. But today, we think that's not a mediation. So what's the magic behind this? Why we're telling the present mediation concept as perfect? Why not then concept mediation is wrong? I think it's my personal observation. Yes, empowerment of the parties is an important. Empowerment of the parties involved to take the decision is the most important. How we describe it is not a matter. Every language has own definition. That's another thing. But is my personal view, the main motto should be like this: whether the parties involved in the disputes are being empowered or not to take their decision. That's the magic line, I think.
But Judge Halim, what I will
That's
do
why.
is, what I want to
Yes,
do,
that's
yeah.
yes.
No, well, first, let me just introduce the
Oh,
symposium
oh,
that we are
yeah.
doing.
Yeah.
Mediation, legislation, how, what, when, where, which,
Yes,
how, why
yes,
of
yes,
it.
yes, yes, yes,
And of
yes.
course, Judge Halim is going to tell us a little bit about you. Also, you have to tell us. We started off immediately. We have to talk about you also. So but now we have some 50 speakers from 30 countries already.
Okay,
Maybe we'll have
okay.
more people as we go along. So that's one
So
part of it.
yes, yes, yes.
So Judge Halim, a little
Yeah.
bit about yourself, please.
Okay. This is Judge Halim from Bangladesh. I am in Bangladesh in Asia. Is in Asia. It's a besides in India. I am telling about name of India because it's a big country and we are a very small country. That's why it's a besides India. So I'm a judge and mediator, basically having 25 years experience in judicial sector as a mediator and a judge, so sitting judge. And my personal educational background is like that. I have been a graduate from the University of Dhaka with honors LLM, uh, LLB honors LLM, and second master's from Loyola Law School, USA, specialist on alternative disputation. And I am also a senior fellow of GEM. It's a very big chartered arbitration institute. It's very well known over the globe. So besides that, I have some training program on area from USA and from Europe. And here I am doing a job at Jazz, and also side by side, I am working as a mediator as the chairman of BIMAC, Bangladesh International Mediation and Arbitration Center. I am the founder chairman of BIMAC, and BIMAC is one of the firm in Bangladesh to promote ADR and to give the ADR service to the client. That's my in a nutshell, right? So, Vikramji, what I am talking about before this, like mediation, 25 years ago, I was a family mediator, right, in a court and a court connected area. In that time, we had no training at all, but we settled the many cases. And now I think that was totally wrong. Although I settled, that was totally wrong, I should say, before the international speakers. Because some I provoke them to a settlement, and it was a positive settlement. And I was a family mediator, right? When the parties came to me, then I talk to them just like my I am their brother, and I just explain what is the merits of dissolution of the marriage, right? So always I can tell you that I have 5 sittings in a week to make them breathe, right? Make them reconstruction the metal tie. But what happened after metal tie reconstructed, after 7 days, the again dissolved severely by beating the wife severely. And the lady came to me, sir, if I am done. So what? Then I had to arrest, right, that guy. There's a family court mediation I did 25 years ago. That was settled, but actually that was not settled, right? So this is one thing. And another thing I think I should say, sometimes the judicial officers like this, like me, and 25 years ago, there was it's a system, right? I thought sometimes I threaten them. You should do that, or you will be jailed. So you tell me, please, is it a mediation? But I said that. So all settlement is not a mediation, right? If, for example, if I just like a pistol on the table, and please mediate it, please, he signed. Maybe because the people of the the person who comes to the court, right, is always a weak person, right? Behind the scene, lots of things may be done before the mediation table. I'm telling about the co-connected mediation in this point, right? So what is happening behind the scene, we don't know. The judicial officer don't know, but they're coming and they're signing the mediation like this, so-called mediation like this. This is now, as a mediator, I should realize, and that's the mediation. So for the first time, in the beginning, I told that mediation conception is not clear to the people of this region. So in a nutshell, lastly, I should say, not least, in this point, the mediation, it is not a matter. How do you describe it? Not a matter at all. Matter is you should give power to the respondents, right? To take their own decision. And that will be the mediation. So what is in Africa or Asia, no matter.
Yeah, we have to. That's
So
why
now,
in my posts
yes,
also, I first put out a definition of mediation, because yes, we have to have a common understanding without confusing the user. Because the problem is that
yes,
sometimes if you create words in it which will confuse the user as to what transformative, evaluative, facilitative, and all that. So we have to remove that from the user's perspective. But just first, you have to start with what is the legislation today in Bangladesh?
Yeah, yes, I'm coming. The, legislation. So enactment is necessary. Whether enactment is necessary or not, first of all, legislation means enactment. I should say yes, enactment is necessary. Enactment is necessary. So you may ask me the question: if there is no legislation, mediation is going on. Yes, mediation is going on, but it's a like how should I describe? It's like a boat without rudder. Majihin Noka in Bengali term, right? English, right? So it will be without goal, without goal. Someone describe, I describe in a way, I do it in my own way. You may have a chance to do it your own way. So first of all, enactment legislation is necessary, right? On this point. So how it will be done? This is the question, right? Because we have an international understanding, right? We have a role model. I'm coming later on that part. So when enactment is being done, every country has their own choice. They have to give value to their local custom, local religion, local is like this. So lawmaker always think this like. But a mediation is a global matter, so it can be done. And in all cases, mediation cannot be done at all. So mediation only can be done in the cases where in the disputes where the mutual understanding. So with the mutual understanding, we can use the mediation, right? So there is no problem to local embargo. There is no local embargo to enact the laws, right? Every country has some laws. For example, we don't have mediation act, right? But we have some provision. I believe from my heart that many countries, although they don't have mediation law, there is no enactment, there is no legislation, but they have some provision about mediation in their legal system, right? For example, you can I can send, but you can have idea also. Family courted, right? The family courted, we have some provisions, right? Suppose we can in this part of Bangladesh, I can give an example. We have two sections like this. The court shall try, mediate the cases, pre-trial, post-trial. So there is a scope. There is a scope. Although we don't have mediation acts, right? So in our civil cases, I am telling my countries for example. So I believe many countries like have this. In civil cases, we have section 89A, as similar as India also. We have inserted 2007, right? Mediation provision. The court shall try, mediate the cases. It is matter of civil cases. So there is a provision you can see. We have some provision in labor code. We have some provision in Octorin. This is a money loan cases, right? Octorin in Bengali, this is money loan cases. So scattered way, we have some provision. But now it's time to formulate one combined rules and regulations, right? This is legislation. And I think, I believe, not think, I believe, as soon as the legislation will be done, the mediation will have more movement, right? More. Yeah. So now, when this is the high time, I should say this is the high time because in the, except this region, very other region of the world go very they're in advanced position, right? To have their mediation process or legislation like, but in this region also, and also some African region, we don't have some legislation. So, but we need, and it is the high time to formulate the legislation, to formulate the laws, like laws and regulations, right? So how? It may be in two ways, right? So we have a model role, model law, right? So we can drive help from them and also from our judiciary or ethics code. Can formulate some rules because ethics rules made by the ethics code, right, is a mandatory provision. So if our High Court division or Indian High Court institution, not India because India is in a very in advanced position, but the countries where the legislation is not at all, in those countries, my thinking is not suggestion, my thinking is like that. The ethics code of those countries may set up some rules, right? Yes, these are the rules. You have to follow this. You have to follow this like this. So it is mandatory to all the lawyers and I should say stakeholders, the judges or like the practicing lawyers or every. And after after practicing some years, they can just maybe I
Up till yeah. You'll have to unmute yourself.
okay. That's not okay. I'm just implying power. So High Court, apex court is the main can do the main thing for time being. For time being, they can set some rules of mediation, and the whole of the country stakeholders may run on these rules. After being practiced for some time being, 2 years or 5 years, that is the stakeholder is being practiced, right? Then the lawmakers can, right, may enact the law.
Judge Halim,
This is my suggestion.
I'll tell you the question. You're the right person, or maybe the wrong person to ask the question. My question is, what is the connection of courts and judges and mediation? They're two different concepts. Mediation has nothing to do with the court system, nothing to do with judges. It's a totally different process. Why this linkage? Should there be a linkage between the two? I mean, why do we, like you said, start with even the courts even telling people or anything in relation to mediation? Why are we not being?
There's a relation. I am telling why I'm telling you about this. Because mediation and judge are the two parts. Right? This is a part. In the Indian subcontinent, it's a British colony, right? So we are practiced law on British laws for 200 years ago. There is a hurdle, the main hurdle to accept new things in this region by passing the British laws, colonial laws. People, myself from my born, are habituated to see if there is a legal infringement, I should go to the court. Nothing else. If there is a problem, I am looking for a lawyer. But now the theme, no, if I make them understand, no, you don't go to the lawyer. You please find the mediator. They will, what is mediator? Who is he? Get out from here. So this is not practicing.
You hate the right thing.
This is not practicing. For this practicing, some constant the people have to be bound. And how? Because you have no law, you don't have law. So this is the code, apex code. Apex code is the guardian of legal paternity. So they may have. That's why I'm telling.
My question has always. Well, I'll give you an analogy there. That the Medical Council of Bangladesh says that you have to use Ayurveda. We are going to regulate Ayurveda. I mean, natural form of whatever wellness and all that. So. Ayurveda is what we use. I'm sure you have the same terminology. So the medical council is talking about a way of healing, which obviously has nothing to do with them. But because over time, over hundreds of years, maybe this concept has been put in their head that modern science, modern medical science is where what
Yes.
you have to do. So they should be talking about it. I'm saying they can't talk about it because they have nothing to do with it. So I'm just saying similarly,
Yes.
because
Yes.
what you said was an
BMA, BMA, Bangladesh Medical Association, is an organization of the doctors, right? If you can set the example, it will be more if it's the Bangladesh Lawyers Association, right? If the Bangladesh Bar Council advises you, please do the mediation, right? That is the more correctly.
Ayurveda.
So
I'm saying
they will,
Ayurveda.
they will, because they have no power at all. They have no power at all.
No, they don't understand anything about the Ayurveda. You know what Ayurveda is?
No,
The
I know
Ayurveda.
very well. I'm very
Yeah,
well known to make country.
exactly. So
Yeah, very
Ayurveda
well known to my
and
country.
the,
It's
I
a
mean,
very
doctors.
fictive, but yes, I understand the point. PMA, medical Bangladesh Medical Association, Medical Council, or like Doctors Council, if they advise Ayurveda, cancel is cancelled. But they have no power. There is a body of this is the association. But I'm telling you of the apex code. Why? Because apex court in India, apex court in Bangladesh, always the Supreme Court as the guardian of the constitution, is the guardian of the legal. So they think how the judiciary, I know judiciary, how the legal family, how the legal atmosphere will be better understanding, right? So they can, they can step forward to take some steps. I use the word for time being. It may be for 2 years, 3 years, 5 years like this. Okay. Then, because ultimately it should be done by the parliament. So parliament is not coming forward, right? Parliament is, this advice is only for this for some time being. Nothing,
No, but
nothing
doesn't mean
else.
that the provisions for in the civil procedure code in
Yes,
Bangladesh
we
and
have.
India
We
also,
have.
it's been for
It's not,
now,
yes.
it's been almost 20 years since they've been there. It's not so, it's like even legislation came in for the judiciary. Civil procedure code is only applicable in the court system, nowhere else. So in the court
Now we are
system,
talking about all the mediation in also private,
no,
private, right?
what I'm
Also,
saying is,
also.
yeah, no, what I'm saying is that in the court system, even the legislation is available. Even then, in 20 years, mediation has not become popular. So to say that is the route to take has failed. It's totally failed because if it had, because fine,
Lots of,
no,
there are many
fine,
reasons there.
yeah,
Yes, in my
exactly.
country also.
Yeah,
There's
because
many
same
reasons.
thing. So we
One,
are trying to
yes,
what we're trying to do is that instead of looking at how maybe it's structured in Bangladesh or India or anywhere in the world, because you have the experience on the ground as well as in the courts. So let us for a moment just not think of what is happening. Let's look at it. How would you want legislation to be if you feel for basically for the promotion and development of mediation? How should
yes,
legislation look? What should it look like? Just all your thoughts on that. That would be an important way to start.
yes. Yes. My thinking is like that. Legislation is a mandatory today. Mandatory. How it look, right? How does it look like this? I dream in Bangladesh, right? So we have two setup in court system in every district like this, civil court and suppose like this, magistrate court, civil and magistrate court. Right? We can put up a mediation, or there can be another set of mediation side, right? Mediation side. So if these three setup work together, that will be done. So my dream is that I dream in Bangladesh. I always speak of mediation. How can it be done? We can be a mediation central mediator like this. What with the post? Not nothing else, right? We have some one legal aid officer like this, director, so register of the mediators like this, supreme one person, chairman like this with 5 members in a commission, mediation commission like this. So okay, so there with a very wisest man like mediator, professional mediator, there 4 or 5 body. Okay, they can formulate like this there. So every district they have some representative. They will train. The judges who work for the mediation, although I have some confusion how mediation they are doing, because I am a judge also, right? So I don't know. But nowadays they have some experience. They are doing better, I should say. It's another matter. So if the Central Mediation Commission or the Registrar General of the Mediator, what should the name is nothing, but one person should be like head of the body, right? Consists of 5 or 6 or 10 bodies, central body. This body have some delegation power to the every district. So every district mediators officer in like Sri Lanka, there's a mediation officer who goes there and trains some lawyers, some mediators from the others profession. And in Bangladesh or like India also, there's a mix. There's a false idea like this. The lawyers also should be the mediator. I don't know why they think like this. They think the lawyers think that yes, this is our profession. No, this is wrong, totally wrong, totally bogus. Yes, mediators can be from any profession, right? So they mediators from the central body go to the district to set up, right? They can train some of the professionals, NGO workers, teachers, bankers, engineers, right? So like this work. So this is how we can do like this. Please.
But I'm
You want to
thinking that,
something?
yeah, I was saying to Jalim that one is, of course, we think that the government should create these kind of positions and do it from there. But what on the other side, we say that the government and judiciary stay away from this. Let it be a people's process and people's development. Like you said, you have this center. I mean,
Yes.
you're creating some kind of a program there. But important thing for me has been that we have to strengthen what is already there, which is we have mediators in communities and families and everywhere. How do we strengthen that so that these are people who are already trusted? They're trusted by people in their communities and they have the mediator mindset. So I am saying that for me, legislation should be such which can strengthen that part, not be able, not create this whole thing again that, oh, this is someone else coming to us and that person is the one who's going to resolve for us. And that same colonized
Yes.
kind of a mindset.
Yes.
So I
Yes.
just feel that
Yes.
we need to maybe, do you think we need to look at it from that legislation if required? Because I have put out in my post also, and I keep talking about it. I look at the Indian legislation on mediation. For me, that's the best. I mean, little tweaking might be required somewhere, but that is okay, very simple. But the important thing is that the way it's structured, what do we require in a mediation? Because that's the important part. If in the
Yes.
legislation, for me, the important things that came out from that legislation are confidentiality protected, the process is
Yes.
without prejudice, the
Yes.
mediator cannot be called
Perfect.
in as a witness. These
Perfect.
are three
Perfect.
things that you need to protect.
Perfect.
Beyond that, you want to give total flexibility to the people that whom they want to have as a mediator. It has to be theirs. We can't tell them whom to trust. So full
Yes.
flexibility on whom they want to choose. How the process has to go on is totally the way they want it. Some people, I mean, it's for every moment you're in the mediation, you're not forced to be in it. You can walk out when you want. So that environment that they are a part of, it's their that's their process. So if they're not I mean, happy with the way things are going, they can always walk out. So we're trying to create this thing that we are forcing in
Yes.
something which we have
Yes.
something. I mean, yeah.
I may forget like say, one thing is because why legislation is most necessary, because we are facing some serious problems in execution of the award, right?
Because yeah,
If there is no, as we
yeah.
have no law, so if there's a breach of mediation award, so nothing is to be done. The involved parties again has to file a case. So you are going to again back to the
No,
court
Judge Halim,
system.
in our law,
So you are missing. You are missing. You are
no,
wasting
no,
your
no,
time.
no, in our settlement
We
agreement,
cannot answer them. We
no,
cannot
in our,
answer
I'm
them.
saying in our law, the settlement agreement is as good as a court decree in our law.
But here in a judicial system is one. But if other side, nothing else. Suppose I am a mediator, right? You and then Miriam is there next speaker.
Yeah.
For example, yes, Miriam and you are the parties. I am the mediator. So we reach in a settlement, right? So part payment is done, and part payment will be 1 month later. So if you breach the next payment, so what will happen? Yeah, nothing else. Nothing else. So when we speak of mediation in our country, the people say, sir, it is meaningless. Just a waste of time.
No, but Judge, that's what I'm saying. In our law, that settlement agreement is as good as a court degree. It
I
can
know,
be
I know, I
enforced
know.
as a court degree. You don't have to go through a suit. So I'm saying that
Yes.
our law takes care of all
Here
this.
is a basic difference in my country. Basic difference. So if there is a law, right? Mediation law enactment, right? Or legislation, so it should be worked out. It should
Yeah.
be worked out. That's why for this reason, many disputes are being settled by the business association. In the market, there is a market committee like this. Then some enforcing them. You do that, give money back.
That is a problem.
Give money back, please, or you will be expelled from the market. Your shop will be shut down. This is threat,
Yeah.
right?
But let's guess what.
For mediation.
Let's get Mariam in. It's Mariam's time now. So Mariam, you want to come in?
Yes,
You want to say
yes.
hi? It's her time now. So we'll have to bring her in. But what I'm saying is that we have to be careful in relation to how this is being perceived, because you said traditionally there has been mediation. We have to distinguish between was it actually mediation or was it arbitration?
Yes.
Were they forced into it? So even that we have to do. So Mariam, is your time. You can come in. So Judge, you want to conclude? You want to give
Okay, bye-bye.
you want to any closing
Bye-bye.
remarks or anything you want to put in?
No, thank you very much for inviting me here. I will be with you for you are doing excellent thing for promotion of mediation. I like it too much. I always follow your channels, and really you are doing awesome. So I am always with you for mediation. Thank you.
Thank you, Judge. Thank you.
Bye-bye.